Welcome to the Supreme Court Podcast. All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
Hi, I'm Attorney Mike Navalio, Supreme Court Chief Communications Officer. It's the 3rd of January 2025, and we open the new year with a look back at the significant Supreme Court decisions for 2024. And joining us to talk about these cases is Supreme Court Spokesperson Attorney Camille Ting. Hi, Attorney Camille. Welcome to the Supreme Court Podcast. Happy New Year.
Hi, Attorney Mike. Thank you for having me here again. Happy New Year to you and to all our listeners.
Right. So let's talk about 2024. How did the Supreme Court fare in terms of case output for that year?
Well, for 2024, the Supreme Court disposed a total of 4,294 cases, achieving a disposition rate of 22%. Its clearance rate stands at 87%.
When you talk about clearance rate, disposition rate, what do we exactly mean, Attorney Camille?
So the clearance rate shows how many cases are resolved compared to the number of new cases filed, while the disposition rate tells you the percentage of cases that have been resolved by the court out of all existing cases.
Right. So of these total case output, let's try to break them down according to fundamental rights. And let's begin with the right to life, liberty, and security. I recall that among the more remarkable cases decided last year, the case of Diduro versus Linoya was one of the most talked about, where the Supreme Court defined for the first time in the main decision the concept of red tagging. How significant is this case, Attorney Camille?
Well, Attorney Mike, this case is important because the court ruled that red tagging, vilification, labeling, and guilt by association can threaten a person's right to life, liberty, or security. This means that individuals deserve protection under the writ of amparo. The court in this case called red tagging a form of harassment and intimidation. Labeling someone as red usually leads to constant surveillance, direct harassment, and sometimes even death.
So talk about the writ of amparo. What kind of remedy is this, just for the benefit of our listeners?
So the petition for a writ of amparo is a legal remedy available to anyone whose right to life, liberty, or security is being violated or threatened. This must be due to illegal actions or negligence by a public official, employee, or a private individual or organization.
And why was it granted in the case of Castro versus De La Cruz, but not in the case of Roque versus House of Representatives Quad Committee?
Well, in the case of Castro versus De La Cruz, the court granted the writ of amparo to environmental advocates after finding evidence of enforced disappearance. The court noted the affidavit from a Rapatan Gitnang Luzon member detailing witnesses' accounts of the abduction. Number 2, statements from the petitioners that they left their shoes behind during the struggle. And 3, photos of the shoes at the abduction scene confirming their statements. So basically, the court found that there was evidence to show that there were enforced disappearances. In the case of Roque versus House of Representatives Quad Committee, on the other hand, Attorney Harry Roque asked the court for a writ of amparo to prohibit the Quad Committee from arresting him, requiring him to attend future hearings and producing documents. But the court denied his prayer, ruling that amparo is not the proper remedy against congressional contempt and detention orders. The scope of amparo is limited to extralegal killings and enforced disappearances or threats thereof, which are not present in his case.
Assuming that you find yourself at the receiving end of abuses by law enforcers, for example, are there remedies that you can resort to in order to question how you were arrested?
Oh, yes, there are. In the case of Bismonte versus Napolcom, the court found a police officer guilty of simple misconduct for using unnecessary force and violence during a buy-bust operation. The court emphasized that it does not approve or condone of police officers using force indiscriminately against people who are under arrest. In another case, Redon versus People, the court emphasized that simply violating ordinances and regulations is not enough to justify a warrantless search and seizure, especially when the penalty does not involve imprisonment.
So, Attorney Camille, what if you have been detained or imprisoned way longer than you should have?
Attorney Mike, in the case of People versus Agustin and Antonio, the court ruled that keeping someone in prison longer than the maximum sentence is cruel and goes against the dignity of the person. The court emphasized that when courts send someone to prison, they must also release them if they have been held for a time that is equal to or longer than the maximum penalty. In the case of Ginto versus DOJ, the court overturned the DOJ's rules that prevented certain offenders, like repeated offenders, habitual delinquents, escapees, and those convicted of serious crimes, from getting good conduct time allowance credits. The law itself did not exclude these groups. The court clarified that Article 97 of the Revised Penal Code states that all convicted prisoners should earn good conduct time allowance credits as long as they are in a penal institution, rehabilitation center, detention center, or local jail.
Mm-hmm. And what about due process? What did the Supreme Court say in recent rulings?
In the case of People versus Valencia, the court decided that even a small change in the receipts recording the movement of seized drugs can damage the chain of custody in drugs cases. In another case, the court used its constitutional power to change the location of a trial to ensure a fair process. It approved Justice Secretary Remulla's request to move two criminal cases against Apollo C. Quiboloy from the Regional Trial Court of Davao City to the Regional Trial Court of Quezon City. A key case on due process is Togado versus People. In this case, the court set rules for when a confiscated firearm must be shown in court. The court highlighted that in cases of violations of the Comprehensive Firearms and Ammunition Regulation Act, the absence of the confiscated firearm in court cannot be ignored. It also stated that just having a certificate saying the accused does not have a license for the firearm is not enough for a conviction.
Mm-hmm. Now, let's move on to the right to free speech. Suppose you make statements against public officers regarding their discharge of official duties. Will you be liable for oral defamation or slander?
In Labargan versus People, the court ruled that statements about public officials do not count as oral defamation or slander when they relate to their official duties, unless those statements are made with malice. The court acknowledged the right to free speech allows citizens to hold public officials accountable because public office is a public trust.
But what if what you talked about was in the context of legal proceedings? Does it matter if you're a litigant or a lawyer as part of a case, or if you're a journalist, for example, covering the proceedings? What about comments made on social media? Are there different rules for this?
In the case of ABS-CBN Corporation versus Ampatuan, the court established boundaries for free speech by participants in legal proceedings. It set clear guidelines for punishing indirect contempt. The court recognized that speech made on social media falls under this regulation, marking it as the fourth type of regulated speech. This acknowledgement comes from the concern about fake news spreading on social media and its effect on public trust in the justice system.
Attorney Camille, one topic that has been talked about recently in social media is the right to privacy. To what extent can you invoke this right to defend yourself in court? To what extent can prosecutors also use private messages against you?
In the case of People versus Rodriguez, the court reiterated that using online chat logs and videos as evidence does not violate the right to privacy if these are used to determine if a crime has been committed. The Data Privacy Act allows the processing of sensitive personal information to determine a person's criminal liability and to protect the rights and interests of persons in court proceedings. Another decision on privacy is IBP versus Purisima and Jacinto Henares, where the court upheld the right to privacy of professionals and their clients. It invalidated a BIR regulation that required self-employed professionals to submit their appointment books in order to monitor their tax compliance.
Yeah, Attorney Camille, the 2025 midterm elections are just a few months away. Notably, the Supreme Court decided on several election-related cases last year. Two of the high-profile cases decided are the cases involving P3 PWD party list nominee Rowena Gonzon in Duterte Youth versus Comelec, who was prevented from substituting another nominee. It also affirmed the Comelec's disqualification of the Rosal couple as governor of Albay and mayor of Legazpi City, respectively, for the 2022 elections. That's Noel Rosal versus Comelec and Geraldine Rosal versus Comelec. In National Press Club versus Comelec, the court issued a writ of mandamus to compel Comelec to allow the witnessing of the printing of ballots. But in another case, Rio et al. Versus Comelec, it rejected the mandamus petition seeking to compel Comelec to do a recount of ballots. Can you explain to us how these two rulings are different from each other?
In National Press Club versus COMELEC, the court ruled that the Commission on Elections, or COMELEC, may be compelled via a writ of mandamus to allow people to witness the printing of ballots, as this is the COMELEC's duty under the Omnibus Election Code. Once a request is made, it is the COMELEC's ministerial duty to allow the designated watchers to observe the printing of the ballots. In Rio versus COMELEC, however, the court held that the issue did not involve a ministerial act by the COMELEC, as the requested recount of physical ballots requires the exercise of COMELEC's discretion and judgment.
Why did the Supreme Court prohibit COMELEC from holding plebiscites to ratify the creation of new municipalities in the province of Maguindanao del Norte in the Bangsamoro Autonomous Region in Muslim Mindanao?
In the case of Sinsuat versus Ibrahim, what was being challenged were Bangsamoro Autonomy Act numbers 54 and 55, which created the municipalities of Datu Sinsuat Balabaran and Sheikh Abbas Hamza from the municipality of Datu Odin Sinsuat Maguindanao del Norte, and Bangsamoro Autonomy Act number 53, which created the municipality of Nuling from the municipality of Sultan Kudarat. The court declared unconstitutional Section 5 in Bangsamoro Autonomy Act numbers 53, 54, and 55. Section 5 allows only the qualified voters of the barangays comprising the new municipalities to vote in the plebiscite. The court ruled that qualified voters from both the new and mother municipalities should be included in the plebiscite. Thus, COMELEC was enjoined from holding plebiscites to ratify the creation of the three new municipalities.
Well, remaining on the topic of the Bangsamoro Autonomous Region, Muslim Mindanao, why did the Supreme Court decide to uphold the validity of Republic Act number 11054, or the organic law for the Bangsamoro Autonomous Region, Muslim Mindanao, but declared the province of Sulu not part of BARM?
Well, in this case, the court ruled that the Bangsamoro Organic Law is constitutional because it does not make the Bangsamoro Autonomous Region in Muslim Mindanao, or BARM, a separate state from the Philippines. The law does not grant BARM the authority to engage in relations with other states, nor did it grant the BARM its own sovereignty. Matters of national defense and security, citizenship, foreign policy, and foreign trade remain with the national government. The court, however, declared that the interpretation of the law, which directed the provinces and cities of the Autonomous Region in Muslim Mindanao, or ARM, to vote as a single geographical unit was unconstitutional. This interpretation improperly included provinces that did not vote in favor of inclusion. It violates Article 10, Section 18 of the Constitution, which states that only the provinces, cities, and geographical areas that vote favorably in the plebiscite can be included in the autonomous region. As Sulu rejected the Bangsamoro Organic Law in the plebiscite, it was wrong to include the province in the BARM.
Mm-hmm. And returning to cases now involving COMELEC, why was COMELEC's cancellation of Anwaray party list registration upheld by the Supreme Court?
The court, in the case of Anwaray versus COMELEC, upheld the cancellation of Anwaray party list registration based on Section 6, Paragraph 5 of the Party List System Act, which states that violating election laws, rules, or regulations is a ground for the cancellation of a party list's registration. In this case, the court found that Anwaray violated a resolution of the National Board of Canvassers. This resolution declared that Anwaray was entitled to only one seat in the final distribution of party list seats. However, Anwaray allowed its second nominee to keep her seat in the 16th Congress, despite the COMELEC's orders that Anwaray was only entitled to one seat.
Mm-hmm. But can a party list organization have a say on how to interpret its own internal rules on how to remove their officials?
Yes, in the case of Magsasaka Party List versus COMELEC, the court decided that party list groups can interpret their own rules for removing officials. The court found that Soliman Villamin Jr. was properly removed from his role as national chairperson of the Magsasaka Party List according to the group's own rules.
So aside from all of these cases, Attorney Camille, the Supreme Court also had some rulings on separation of powers. Can you tell us briefly about these cases?
So, Attorney Mike, in Byong versus COA, the court ruled that the Commission on Audit, or COA, cannot expand its audit powers to include imposing administrative penalties, as the COA's authority is limited to initiating the proper administrative, civil, and/or criminal action upon discovering a violation during an audit. Imposing administrative penalties is beyond the scope of its audit powers. In another case, the case of Fejadap versus Manila City, The court also affirmed the exclusive power of the Manila Metropolitan Development Authority, or MMDA, to enforce traffic laws, rules, and regulations over local governments in Metro Manila. While in the case of MWSS versus Bulacan, the court affirmed its decision that the MWSS is not required to share its proceeds from the use of Angat Dam with the Bulacan government.
And just to close our discussion, Attorney Camille, 2024 has been a year where the Supreme Court is in the process of updating guidelines for lawyers and guidelines for court personnel. It is in the process of passing updated codes. Tell us about cases where the Supreme Court tried to cleanse the bench and the bar of erring individuals.
So the court punished several judges for misconduct. In the case of Oka versus Reyes, the court dismissed a judge for gross misconduct after discovering messages on his laptop where he asked lawyers and litigants for bribes in return for favorable decisions on their cases. The court also received an anonymous tip about a judge and a court employee in Pasay City being involved in bribery. To address this, the court asked the NBI for help. After an entrapment operation, the court ordered the preventive suspension of the Pasay City judge and the acting branch clerk of court to ensure a smooth and thorough investigation. Another judge was removed by the court for falsifying official documents and serious dishonesty. She had made false certifications and misused her staff's salaries. The court also punished court employees who broke the rules, reminding all staff to act honestly and maintain the public's trust in the judiciary. For example, the court fired 3 Court of Appeals employees because they tested positive for shabu for the second time. The court penalized lawyers who did not follow the rules also. In a case involving the Public Attorney's Office, or PAO, the court fined Attorney Persida V. Rueda Acosta, the chief of the PAO, for showing disrespect to the court. This was due to her conduct, which was deemed harmful to the justice system. Her actions related to her opposition to a new conflict of interest rule for the PAO, which later became Section 22 of Canon 3 of the Code of Professional Responsibility and Accountability. In Garrido v. Gadon, the Supreme Court found previously disbarred lawyer Lorenzo G. Gadon guilty of gross misconduct for committing perjury and making accusations based on hearsay. And in AM number 23-04-05-SC, the court found Attorney Nilo T. Divina guilty of simple misconduct under the CIPRA for impropriety when he sponsored the trips of Integrated Bar of the Philippines Central Luzon officers.
Right, so quite a year that was for the Supreme Court. Lots of cases. I hope our listeners are given a taste of how the court ruled in the past year. So thank you so much for joining us again for the nth time, Attorney Camille.
And thank you again for having me, Attorney Mike, and Happy New Year to everyone.
Right, and if you wish to read the full text of any of these decisions, you can go to the Supreme Court website and e-library and search for the specific cases. Here's Steph Atendido Beltran, Supreme Court Information Officer, for this week's Roundup.
At the Supreme Court this week. The Supreme Court reminded that while moneylenders can acquire properties used as loan collateral, ownership cannot be automatically transferred to them unless there is a separate agreement. In a decision written by Chief Justice Alexander G. Gismundo, the Supreme Court First Division upheld the transfer of ownership of the land owned by Ruby Shelter Builders and Realty Development Corporation to its creditor, Romeo Y. Tan and Roberto L. Oviedo. The SC held that this transfer was based on a valid agreement and did not violate the law prohibiting the automatic transfer of collateral ownership. Ruby Shelter borrowed money from Tan and Oviedo, using several properties as collateral. When the outstanding debt reached 95 million pesos, the parties signed a Memorandum of Agreement, or MOA, to sell their properties to Tan and Oviedo as payment for the loan. The Supreme Court upheld the validity of the MOA and held that Ruby Shelter voluntarily entered into the MOA to sell the subject properties. The court also explained that the MOA does not constitute a pactum commissorium or a prohibited agreement under Article 2088 of the Civil Code. This provision states that a lender cannot automatically obtain ownership of the collateral if the borrower fails to pay. A pactum commissorium occurs when 1. a property is used as collateral for a loan, and 2. The loan agreement includes a provision automatically transferring ownership of the collateral to the lender if the borrower fails to pay. In another case, the Supreme Court emphasized that search warrants must clearly define the location to be searched. Otherwise, they are invalid for violating the right against unlawful searches and seizures. The Constitution requires a valid search warrant to particularly describe the place to be searched. This requirement is crucial to prevent enforcing officers from deciding on their own where to search and whom and what to seize. The SC also stressed that government agents must first identify themselves and ask for permission to enter the place they want to search. They can only force their way in if they are denied entry. This rule protects both the person being served with a warrant and the agents from possible violence that could happen from an unannounced entry. Additionally, searches must be made with the lawful occupants of the house as witnesses, or if they are unavailable, two residents in the same area. This decision of the SC Second Division, written by Senior Associate Justice Marvic MBF Leonin, acquitted Lucky Enriquez of the crimes of illegal possession of dangerous drugs and drug paraphernalia under Republic Act No. 9165 or the Comprehensive Dangerous Drugs Act of 2002 due to a defective search warrant and its irregular execution. The Office of the 2025 Bar Examinations Chairperson, Supreme Court Associate Justice Amy C. Lazaro Javier, has reminded that the Bar Applicant Registration Information System and Tech Assistance, or Barista, may be accessed beginning 8 in the morning on January 8, 2025 for applications to take the 2025 bar examinations. The application period will be until 3 in the afternoon on March 17, 2025. For bar bulletins and other information about this year's bar exams, you may visit the Bar 2025 microsite at the Supreme Court website, sc.judiciary.gov.ph. Meanwhile, the Office of the 2024 Bar Chairperson, Supreme Court Associate Justice Mario V. Lopez, reiterated that the oath-taking and roll-signing ceremonies for the 2024 bar examinations shall take place on January 24, 2025 at the SMX Convention Center, Manila in Pasay City. A total of 3,962 passed the 2024 bar examinations for a passing rate of 37.84%. The 2024 bar examinations were held on September 8, 11, and 15, 2024 in 13 local testing centers in the National Capital Region, Luzon, Visayas, and Mindanao. The 2024 bar examinations were the 122nd professional licensure tests conducted for aspiring lawyers in the Philippines. And that's your Supreme Court this week. I am Tiffany Doblatran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navalio, your Supreme Court Chief Communications Officer. You can catch this podcast on the Supreme Court Public Information Office's accounts on X, Facebook, Instagram, Threads, YouTube, and Spotify. You can also catch previous editions on our website and on Spotify. This podcast episode was produced by the Supreme Court Public Information Office with Attorney Jen Tuazon Irania as researcher, Victor Laranio, Brian Austria, and Don Ryan Balza as sound editors, and Tyke Flores and Jerome Batumalake as web editors.